Minister Shan.
Mr. Chairman, I thank the members who spoke. I will start with an overview of the legal reforms in our civil, family, and criminal justice systems, which Mr. D'Souza spoke about. In the area of civil justice, my ministry has been working closely with the judiciary, legal practitioners. The aim is to keep legal costs affordable and to reduce the complexity of civil proceedings. We are also studying measures to strengthen the enforcement of civil judgments. Public consultation is likely to take place later this year. Mr. Patrick Tay asked if we will be raising claims limits in the small claim tribunals. The answer is yes, we will be. Amendments will be introduced this year. It will allow claims of a higher value, and we hope it will allow the claims to be resolved quickly, cost-effectively at the SCT. On family justice, members know that in 2014 we made changes. Reforms brought about several positive developments, including providing child and family-friendly approach, where the courts look at what's in the interest of the children, how best to deal with it, how to try and move on with as little acrimony as possible. To build on these reforms, my ministry has set up a committee with MSF as well as family justice courts. We've asked them to review and further enhance the family justice system. The report will be out later this year, and we will act on it. On criminal justice, I've said earlier during the Home Affairs debate, we want a progressive, balanced, modern criminal justice system. And if you look at it over the years, there have been a series of reforms, each building on the other. The pretrial disclosure regime in 2010, the CBS, which was also introduced in 2010, these changes to the Evidence Act in 2012, and in 2015, in a fairly significant move for the government funding legal representation of accused persons through the Criminal Legal Aid Scheme, and now comprehensive amendments to the CPC and the Evidence Act have been introduced in Parliament earlier this week. Mr. D'Souza asked whether we will have 3 High Court judges to sit in trials for capital cases. We haven't yet seen a need to review this, but it does not mean no. Members will know that since 2012, if a person is sentenced to death and chooses not to appeal, a confirmation hearing must still be held by the Court of Appeal. That ensures that the imposition of the capital punishment is always reviewed by the apex court of at least 3 judges. So there is already a 2-level process with at least 3 judges of appeal looking at the matter, but we will review the point made by Mr. D'Souza. I will now speak on our commitments towards advancing international rule of law. I think Professor Mohan spoke about it. We see ourselves as a responsible and effective member of the international community and a firm believer in an international rules-based legal order. And adherence to the international rule of law is integral to our security and survival. And to that end, we have do a number of things which I think Ministry of Foreign Affairs has spoken about and I've spoken about previously, so we do not need to repeat that. But we have to continue our engagement with the international community, other states, and our development of international law expertise in relevant emerging issues. And we should support think tanks which are doing research in these areas. Examples are the Asian Business Law Institute, the Center for International Law, which are supported by us. And we have to actively participate in international lawmaking at regional and multilateral forums. bring our interests and values to the table. And we have done that. People know of our crucial role in UNCLOS. We have led multilateral negotiations on online dispute resolution and dispute settlement. And right now, we are playing a very important and key role in the UNCITRAL working group on dispute settlement. This is under the chairmanship of a MINLAW director. We have completed work on both a draft convention and amended model law that will provide for cross-border enforcement of international commercial settlement agreements resulting from mediation. The Singapore delegation is well regarded in the international discussions on insolvency, on electronic commerce, on recognition and enforcement of judgments. And we are committed to peaceful international dispute resolution mechanisms. It's important for a small country like Singapore. And we serve as a neutral venue for state-related disputes, which is also enabled through the partnerships we have forged, for example, through the Permanent Court of Arbitration and ICSID, amongst others. We also actively participate in discussions on possible reform of investor-state dispute settlement mechanism so that any future disputes on trade agreements can be fairly, effectively resolved. Professor Mohan asked if international trade law will help the government respond to announcements of fresh tariffs by our in consultation with the US, and also in our negotiations of the next generation, say, regional FTAs, large FTAs. Well, primarily how we handle these issues will have to be guided by A, what's in our interests, what is in our primary economic as well as strategic interests, and what's the framework of international law, including any applicable treaties. So that will guide us in taking what we consider to be principled approaches when dealing and negotiating with our trading partners. And of course, in these things, size matters as well. Yeah. The second query that Professor Madhav had was, do developments in private international law present new opportunities for our lawyers vis-a-vis clients in India and ASEAN countries? The short answer is yes, they do. That is why we participate actively in international efforts to harmonize private international law and to promote the adoption of Singapore legal principles, standards, but also any sort of civilized set of standards in this area would be welcome, and it will help us. So that will give our lawyers more opportunities, because our commercial law principles are consistent and consonant with the international law standards in most advanced jurisdictions. I will now deal with Mr. D'Souza's question on ensuring Singapore firms, law firms, Singapore-based lawyers remain relevant in the region. Developing Singapore as a dispute resolution hub is in fact one of our key strategies in growing our legal industry. And I've said that there is a role for government, but there is also a very critical role for our lawyers. Right? Government can provide the infrastructure, the framework, the training through the law schools, but ultimately the lawyers must also take part in it. And now the government is even putting money on the table for law firms to go regional. Senior Minister of State Indrani Raja will touch on some of the other strategies, but I will touch on our dispute resolution services. We aim to provide a full suite of such services that will create more work for Singapore law practices and Singapore-based lawyers within Singapore. We have seen, in fact, a tremendous growth in caseload numbers across all our main dispute resolution institutions. Take the SIAC, the SIMC, the SICC. The SIAC, for example, saw between 2008 and 2016, in the 8 years, a threefold increase in cases, from 99 to 343. The total sum in disputes for new cases filed in 2016 hit $17 billion. and 80% of those cases were international in nature. And that's a record. The number, $17 billion. The SIMC had a much later start. It had 22 cases filed in 2017, so it now has 42 cases so far, and it was only established 3 years ago. So to promote international commercial mediation, the SIMC has also partnered with other institutions. For example, in 2017, last year, SIMC signed MOUs with the Mediation Center of the China Council for the Promotion of International Trade, China Chamber of International Commerce, and the Hangzhou Arbitration Commission. This is to help businesses resolve the disputes as they may arise in cross-border transactions under China's Belt and Road Initiative. The SIMC also signed an MOU with Japan Association of Arbitrators to help Japan build expertise in international commercial mediation. So how do we ensure that we remain a destination of choice for dispute resolution? Starting point is people must believe and know that there's going to be top quality legal expertise available here if they come. What the government can do is make sure our dispute resolution legislation framework is modern, is friendly. We will continue to make necessary legislative enhancements to make sure that it is at the cutting edge. For example, we recently amended the Supreme Court of Judicature Act. It clarifies that the SICC can hear matters relating to international commercial arbitration under the International Arbitration Act. So it gives the parties who choose Singapore as a seat of arbitration the certainty that they can benefit from the expertise of both local and international judges who have a wide breadth and knowledge and expertise, judicial knowledge, and all of that can be available from the Singapore courts. The work itself can only be handled by Singapore qualified lawyers from Singapore law practices. So they get an international panel of judges. We also enacted the Mediation Act in 2017, which strengthens the framework for enforcement of mediated settlements conducted in Singapore. It codifies certain matters which were previously dealt with under common law, such as confidentiality of communications in the context of mediation, and it provides for greater certainty and clarity for commercial parties who opt to conduct their mediation in Singapore. Second, we will continue to strengthen our international dispute resolution facilities and infrastructure. Last year, we announced that we will be expanding Maxwell Chambers. Refurbishment works have started. They're on track to be completed by next year, and that will add 120,000 square feet of floor space, and it will triple Maxwell Chambers' current size. So obviously, it will allow more cases to be heard. So my ministry will continue to support the development, expansion of our international law capabilities. Mr. Edwin Tong asked about our plans to optimize our land resources. Mr. D'Souza asked about support for Smart Nation Drive. SLA has been allowing old state properties with no immediate plans for redevelopment to be innovatively reused. So that gives the buildings a new lease of life. It unlocks a value for businesses and individuals. A good example is Tanglin Village. It was a former army camp, now home to a wide range of businesses. SLA will continue to find opportunities to convert state properties for different uses, in particular social and community uses. SLA has also opened up previously unutilized spaces for recreational community use. One example is, for example, the Jalan Bukit Merah Viaduct. Under the viaduct, they have opened it up. Mr. Tong had a specific question on Joo Chiat, the sort of, I think you didn't quite say iconic, but buildings. So I'll ask SLA to discuss the matter with the relevant agencies because the policy on this matter is with M&D. So, they will have to decide what land use they have planned for, and we will see what can be done. As regards the Smart Nation agenda, SLA is also building up Singapore's geospatial capabilities through what we call GeoWorks. GeoWorks is a collaborative platform. SLA provides a platform and provides it for geospatial startups, industry partners. Many of them are SMEs or individuals, and they create business opportunities through the use of location-based technology. So we provide the platform, we make it freely available, people jump on into it and create the business value out of it. So our approach to enable, support the private sector innovation as part of our Smart Nation efforts. So, Mr. Chairman, I've covered many different aspects of MinLaw's work. The common framework for this is, of course, advancing the rule of law and making better use of what resources we have, ultimately to improve the well-being of the people. SMS will now take the remaining cuts. Thank you.